Hello and welcome to this episode of the Diary of a Lawyer. And today I want to speak about two or three developments in the legal world. And first among those is the recent decision of the U.S. Supreme Court to strike down long-standing legal principle on affirmative action. So on Thursday, the U.S. Supreme Court struck down the race-conscious admissions program at Harvard University and the University of North Carolina, effectively prohibiting affirmative action policies long raised to raise the number of Black, Hispanic, and other underrepresented minority students in America. Now, this comes on the back of around this time last year when the same Supreme Court, which is now 6-3 conservative to liberals, brought in wide-ranging decisions that struck down Roe v. Wade, which is the issue around abortion, voting rights, etc., etc. The decision, which is said to be powered by conservative judges with liberals in dissent, the court sided with a group called Students for Fair Admissions, founded by anti-affirmative action activist Edward Bloom, in its appeal of lower court rulings upholding programs used at the two prestigious schools to foster a diverse student population. The vote counts were 6-3 UNC and 6-2 against Harvard. And in this landmark ruling last year, again, there were societal implications also, spearheaded by conservative justice, where, as I said, the court overturned the 1973 Roe v. Wade decision that had legalized abortion nationwide and gun rights. Speaking of the White House, the Democratic President Joe Biden said he strongly disagreed with Thursday's ruling, written by Chief Justice John Roberts, and urged colleges not to abandon their commitment to student diversity. Asked by a reporter if this is a rogue court, Biden replied, "This is not a normal court." Roberts wrote that a student must be treated based on his or her experiences as an individual, not on the basis of race. Many universities have for too long done just the opposite, and in doing so, they have concluded wrongly that the touchstone of an individual's identity is not challenged, bested, skills built, or lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice. And according to Harvard, around 40 of US colleges and universities consider race in some fashion. Now, Bloom's group, in lawsuits filed in 2014, accused UNC of discriminating against white and Asian American applicants, and Harvard of bias against Asian American applicants. Harvard and UNC had said they used race as only one factor in a host of individualized evaluations for admissions without quotas permissible under previous Supreme Court precedents, and that curbing its consideration would cause a significant drop in enrollment of students from underrepresented groups. Now, Harvard and UNC admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause, Roberts wrote, referring to the constitutional provisions. Universities, Roberts added, may still consider a student's personal essays about how race affected his or her life, be it through discrimination, inspiration, or otherwise, But Roberts said universities may not simply establish through application essays or other means the regime we hold unlawfully today, which is obviously extremely disingenuous because the Chief Justice knows that race and race discrimination are ingrained in the DNA and formation foundation of the Republican, of course, through the vestiges of slavery and the disadvantages, life disadvantage, intergeneration disadvantages that has caused to present day. And affirmative action was to try to minimize or to mitigate some of those disadvantages that may impact a student, even though they were talented, such as, for example, the economic position of the family or the student, and how that impacts the student's ability to access education, to access support, and so on and so forth. And as the university said, race was just one factor, not the only factor. In other words, they could take into the grades, the ability, the potential of the specific student, and make an informed decision that reflects the totality of circumstances of the student's uh, uh, background, ability, talent, and potential. Now, the affirmative action had withstood Supreme Court scrutiny for decades, most recently in a 2016 ruling involving a white student backed by Bloom who sued the University of Texas after being rejected for admission. The Supreme Court has shifted rightward since 2016 and now includes 3 justices who dissented in that case and 3 appointees by Republican former president who is running again in 2024. Now, many institutions of higher education, corporations, and military leaders long have backed affirmative action on campuses, not simply to remedy racial inequity and exclusion in American life, but to ensure a talent pool that can bring a range of perspectives to the workplace and the U.S. Armed Forces. Now, Thursday ruling appeared to exempt military service academies from its sweep, with Roberts highlighting the potentially distinct interest that military academies may present, and noting that the litigation had not addressed the propriety of race-based admission systems in that context, which is, in my respectful opinion, is nonsense. Basically, what he's saying that it's okay for black and brown folks to go and serve the military, but best taking race as a consideration, but it's not okay in other aspects of intellectual life, and that in itself is how unfairness and race and racism play out in such settings. Now, Biden, who is seeking re-election 2024, recommended that colleges weigh a range of factors in admitting students, including their economic backgrounds, hardships they had faced, including racial discrimination. He said, Porter said, discrimination still exists in America. Today's decision doesn't change that, said the president. And he said that he believes the U.S. colleges are stronger when they are racially diverse, and our nation is stronger because they're tapping into the full range of talent in the nation. Now, it's important to note that the liberal justice, Ketanji Brown Jackson, who is the first black woman to serve on the court, wrote in a dissent with "Let them eat cake obliviousness." Today, the court's majority pulls the ripcord, announces color blindness for all by legal fiat, but deeming race irrelevant in law does not make it so in life. Jackson did not participate in the Harvard case because of her past affiliation with the university, whilst liberal Justice Sonia Sotomayor, the first Hispanic jurist on the court, wrote that the decision subverts the constitutional guarantee of equal protection and further entrenches racial inequality in education. She is quoted as saying, "Today, this court stands in the way and rolls back decades of precedent and momentous progress." Sotomayor added that the court cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter. Bloom's group alleged that the adoption by UNC, a public university, of an admission policy that was not race neutral violated the constitutional equal protection provision, and it contended Harvard, a private university, violated the Title VI of a landmark federal law called the Civil Rights Act of 1964, which bars discrimination based on race, color, or national origin in federally funded programs or activities. Now, Harvard's leaders said in a statement they would determine how to preserve, consistent with the court's new precedent, their essential values. The University of North Carolina President Peter Hans pledged to follow the law. Now, the United States is a nation that long has struggled with issues of race, dating back to the history of slavery of black people that ended only after Civil War, the Civil Rights Movement of the 1950s and 60s, and in recent years, racial justice protests that followed police killings of black people. In May, there was a poll taken by Reuters where 49% of respondents agree that due to racial discrimination, programs such as affirmative action are necessary to create equality, whilst 32% disagreed and 19% were unsure, according to Reuters. Reuters goes on to say that Thursday's ruling did not explicitly say it was overruling landmark precedent upholding affirmative action. But it reports that the conservative Justice Clarence Thomas, who is black, in a concurring opinion, wrote that the court's previous Grata v. Bollinger ruling that colleges could reconsider race as one of the factors in admissions because of the compelling interest of creating a diverse student body is for all intents and purposes overruled. Now, people on both sides of the issue demonstrated outside the court following the ruling, and various Republican presidential candidates and lawmakers lauded the decision for embracing merit-based admissions, whilst Democratic lawmakers called it a roadblock in the drive for racial justice. Bloom celebrated the ruling, saying it marks the beginning of the restoration of the colorblind legal covenant that binds together the multiracial, multi-ethnic nation, which is, of course, complete. It contradicts the history and the lived experience, as we know them, of people of African descent and other groups that endure the remnants and the vestiges of injustices that are rooted in the residues of slavery. And so there we are. Once again, the U.S. Supreme Court Judge 6-9 have overturned a safety net, as they did in the Roe v. Wade and gun rights around a year ago. And what this does, given also the reports of the various suggested impartiality or lack of impartiality due to the donors and alleged gifts enjoyed by some of the judges, further brings the reputation really of the court into tatters. And I think the answer to the question by the president regarding asked by a reporter whether this is a rogue court, and his answer that this is not a normal court or words that effect speaks volumes. And we shall watch development and see how this evolves, and provide updates. And so we shall leave it there on this episode of the Diary of a Lawyer. We shall speak again. Thank you, and thanks for watching. Bye.